So the following are some common questions relating to exhausting administrative remedies in California. So what does exhausting administrative remedies actually mean? According to California's Office of Legislative Counsel, the exhaustion of remedies principle is a fundamental concept of administrative law governing the relationship between agencies and the courts. Essentially, it means that individuals who disagree with an agency action are required to pursue available agency procedures for addressing their concerns before they may sue the agency in court. How have California courts viewed this legal doctrine? It requires individuals to raise concerns about proposed agency actions to the agencies themselves in the first instance, rather than to the courts. And after doing so, the individual can file a civil lawsuit. The Cal Supreme Court said this in Plantier versus City of Ramona Municipal Water District in 2019. That was in 2019. Similarly, in 2005, the Cal Supreme Court said it in Coachella Valley Mosquito and Vector Control District versus California Public Employment Relations Board. Are there instances where state law requires exhaustion of administrative remedies? Yes. For example, Labor Code Section 3085 says, no person shall institute any action for the enforcement of any apprentice agreement or damages for the breach of an apprentice agreement made under this chapter, unless all administrative remedies provided by this chapter have first been exhausted. Similarly, in Unemployment Code Section 3264, it says in part, no such petition may be filed, however, until the employee exhausts the administrative remedies provided for in this division, nor may any other action be commenced by an employee upon a denial of his claim to his employer or insurer, as the case may be, other than that prescribed herein. On the other hand, are there instances where state law provides that administrative remedies do not have to be exhausted before filing a civil lawsuit? Yes. For example, Elections Code Section 17, it says, the Secretary of State shall establish and maintain administrative complaint procedures. The Secretary of State shall not require that the administrative remedies provided in the complaint procedures established pursuant to this section be exhausted in order to pursue any other remedies provided by state or federal law. Similarly, Financial Code Section 23064.6 says, the rights, remedies, and penalties established by this division are cumulative. It is not necessary to exhaust administrative remedies in order to pursue the civil remedies provided for in this part. And Health and Safety Code Section 112275 specifies a person who has exhausted all administrative remedies available within the department and who is aggrieved by a final action or order is entitled to judicial review pursuant to this chapter.